The marble columns of the federal courthouse towered like sentinels over the crowded plaza. Inside, a restless murmur filled the grand hearing chamber. Lawyers whispering strategy, journalists setting up recorders, law students clutching notebooks like talismans. All eyes eventually turned toward the bench where Judge Richard Leon, legendary for his intellect and exacting standards, was about to preside over what many had already called the case of the decade. The polished oak doors opened, and Representative Jasmine Crockett stepped into the courtroom. Her pace was steady, her expression calm but resolute, the composure of someone who knew the weight of the moment. She wasn't just an attorney today, she was a sitting member of Congress standing alone against one of the most powerful technology corporations in the world. Across the aisle sat the opposing counsel, a wall of tailored suits and gleaming cufflinks. Their leader, William Bradford, was a high-profile corporate attorney whose reputation and fees were the stuff of legend. Their client, Tech Giant Corporation, had been accused of systematically harvesting and selling the personal data of millions of Americans. The hearing wasn't even the trial. It was a motion to dismiss, a technical stage where most cases quietly died before they ever reached a jury. But what would unfold in the next 2 hours would ripple across law schools, boardrooms, and Congress itself. Judge Leon entered promptly at 10 o'clock, his robe flowing behind him like a shadow. At 81, he still carried the commanding presence that had made him one of the most formidable jurists on the federal bench. His reputation was ironclad, meticulous, demanding, and utterly unimpressed by theatrics. "All rise," the clerk intoned. As everyone stood, Leon adjusted his glasses and scanned the room. The air seemed to tighten with anticipation. He gave a small nod, and the proceedings began. "Counsel for the defense," Leon said, his voice resonant but restrained. "You may proceed." Bradford approached the podium like a general stepping onto familiar ground. "Your Honor," he began smoothly, "this case should be dismissed. The plaintiffs have failed to establish standing under Article 3 of the Constitution. The Supreme Court has consistently held that a mere statutory violation, absent concrete harm, cannot sustain a federal lawsuit." He spoke with polished precision, citing case after case, TransUnion versus Ramirez, Spokeo v. Robbins, Clapper v. Amnesty International. His tone carried the faint trace of confidence that comes from years of prevailing in rooms just like this. Judge Leon listened intently, occasionally jotting notes. When Bradford concluded, the judge leaned forward. "Mr. Bradford," he said, "you've cited TransUnion repeatedly. How do you address the plaintiff's contention that the data at issue here extends far beyond what was considered in that case?" Bradford smiled faintly when the question was expected. "Your Honor, while the data type differs, the principle remains the same. The plaintiffs allege a technical violation of privacy statutes, but they've shown no tangible injury, no financial loss, no emotional distress. Without concrete harm, there can be no standing." The argument was crisp, predictable, safe. When Bradford returned to his seat, Jasmine Crockett rose. The murmurs subsided instantly. Her approach to the podium was measured, not theatrical, not hurried, just deliberate calm. She placed a single notepad before her, its pages barely filled, and began. "Your Honor," she said softly, "my colleagues have correctly cited TransUnion, but they've overlooked something essential. On page 9 of Justice Kavanaugh's opinion, the court distinguishes between intangible harms that are abstract and those that are concrete because they have deep roots in our legal tradition." Leon's brow lifted slightly. "Go on, Congresswoman." "The unauthorized collection and dissemination of private information," she continued, "has been recognized as a harm since long before the digital age. William Blackstone himself described privacy invasions as actionable injuries under common law. Our Constitution's framers understood that some harms, though invisible, cut to the very essence of personal liberty. There was a stir among the clerks' benches. Bradford's jaw tightened. Leon leaned back. "That's an interesting historical argument, Counselor, but several circuits have rejected it. Are you suggesting I disregard decades of precedent? His tone was sharp, a challenge, not an invitation. The air in the gallery froze. Cameras clicked once, then silence. Crockett didn't flinch. "No, Your Honor," she replied. "I'm not asking this court to disregard precedent. I'm saying those cases don't apply here, for 3 reasons." She raised one finger. First, in those cases, the data was collected but never used or disclosed. Here, tech giant sold user data to 147 third parties without consent. A second finger. Second, those precedents predate TransUnion's clarification of Spokeo. Justice Thomas's concurrence, later echoed by 4 justices, explicitly recognized that disclosing private data to third parties constitutes concrete harm. And a third. The Supreme Court itself acknowledged an unresolved circuit split in footnote 4 of TransUnion. Since then, multiple circuits, including the 2nd and 7th, have held that unauthorized data transfers are concrete injuries. The 2nd Circuit's Thompson v. Data Corp. just 8 months ago made that crystal clear. Bradford turned quickly to his team, flipping through binders. The name Thompson hadn't been in any of Crockett's filings. They had been blindsided. Leon frowned, intrigued. "This Thompson decision, you're confident it's directly relevant?" "Absolutely, Your Honor," she said. "It held that the nature of data, financial or not, is irrelevant when privacy is violated. What matters is the unauthorized transfer itself." For the first time that morning, Leon smiled faintly. "Interesting." Bradford stood abruptly. "Your Honor, Thompson involved financial data and should not be conflated." "With respect," Crockett interjected, "Judge Sullivan's opinion in Thompson explicitly refutes that distinction." Page 27. "The harm lies not in the type of data, but in its unauthorized transfer to third parties." A ripple of quiet awe spread through the gallery. Even the judge's law clerk glanced up, impressed. Crockett had come prepared. More prepared than anyone had realized. For the next half hour, she dismantled each of Bradford's points with surgical precision. Every precedent he'd raised, she reframed or reinterpreted with constitutional grounding. Every procedural argument, she countered with legislative intent. The rhythm of her voice was steady, methodical. A masterclass in controlled persuasion. Soon, even Judge Leon's tone changed. His questions were no longer adversarial. They became exploratory, almost collaborative. "Counselor," he asked, "if we accept your theory, what about cases where data is encrypted before being transferred? Would that still constitute harm?" Crockett didn't hesitate. The D.C. Circuit addressed that in Johnson v. Medical Soft. "Your Honor, encryption mitigates risk but doesn't erase harm, particularly when the receiving party controls the keys, as tech giant did in 83 of its transfers." Leon paused, pen hovering. "You know Johnson?" "That's a relatively obscure ruling." "I do," she replied simply, "because the details matter." The judge nodded slowly, almost to himself. Around the courtroom, people exchanged quiet glances. The momentum had shifted. The center of gravity now fully with Crockett. Bradford rose again, trying to wrest back control. "Your Honor, regardless of these academic distinctions, this is not a matter for the courts. If Congress wishes to create new statutory remedies, that is its prerogative." Leon cut him off sharply. "Are you suggesting this court lacks authority to interpret existing laws in light of modern technologies? That seems inconsistent with your position in DataStream v. Cooper before Judge Williams last year." Bradford froze. The reference hit like a hammer. In that earlier case, he'd argued the opposite, for an expansive interpretation that benefited his client. The inconsistency was glaring. "Your Honor," he stammered, "the circumstances there were—" "Were what?" Leon pressed. "Different or simply more convenient?" A low murmur rippled through the gallery. Bradford's face flushed crimson. Crockett stepped in, voice measured. "Your Honor, if I may address the broader issue Mr. Bradford raises." Leon nodded. "Please." "When technology evolves faster than legislation," she said, "federal courts have a duty to apply established principles to new contexts. The Supreme Court recognized this in Carpenter versus United States. Chief Justice Roberts wrote that courts must preserve the degree of privacy envisioned by the framers, even as technology transforms how intrusions occur. That principle applies not only to government searches, but to private entities wielding unprecedented surveillance power. From the gallery, one of the law clerks whispered, half in disbelief, "She just turned his separation of powers argument on its head." The hearing stretched past its scheduled time. What had begun as a procedural skirmish had evolved into a sweeping seminar on digital privacy and constitutional history. Leon's final question came after nearly 2 hours. His tone was thoughtful now, not skeptical. "Congresswoman Crockett," he said, "the defense maintains that even if every allegation is true, no concrete harm exists that warrants federal intervention. What, in your view, is the most compelling answer to that?" The courtroom fell utterly silent. The question hung there, the fulcrum of the entire case. Crockett stepped away from the podium. Her voice lowered, but every word carried. "The harm, Your Honor, is not theoretical. It is the violation itself." She paused, letting the words breathe. "Our Constitution was built on the principle that privacy is essential to liberty. The Fourth Amendment didn't protect against physical damage. It protected against intrusion. The framers understood that some harms are invisible, but no less real." Leon's eyes were locked on her. "No notes, no interruption. At common law," she continued, "there were torts where no consequential damage needed to be proven. Trespass, invasion of privacy, publication of private facts. The injury was the act itself. That principle still holds." She reached into her briefcase and produced a sealed envelope. "Your Honor, with the court's permission, this exhibit contains sample data tech giant collected and sold, voice recordings captured when the app was inactive, private messages, medical search histories. This is not hypothetical harm. This is evidence," Bradford shot up. "Objection! This material wasn't included in the original filing." Leon waved him down. "Mr. Bradford, a motion to dismiss assumes the plaintiff's allegations are true. I'll review this in chambers." He gestured to his clerk to take the envelope. "Proceed, Counselor." "Thank you, Your Honor." Crockett turned back to the bench. Tech giant would have this court believe that unless consumers lose money, their rights haven't been violated. But what they've done is strip millions of Americans of autonomy, the right to decide who knows what about their own lives. She gestured toward the gallery. Every person here has clicked, "I agree" on a 40-page terms of service document written to obscure more than it reveals. Every one of us has been told our data is anonymous, though 3 simple data points, zip code, birth date, and gender, can identify 87% of us. The room was utterly still now. Reporters' pens scratched furiously across notepads. "Tech giant's own internal documents admit this," she continued. Their chief data officer wrote, quote, "Anonymization is technically true, but practically meaningless. We can pretend it's anonymous while selling identifiable profiles. That is not hypothetical harm, Your Honor. That is deceit and exploitation." Bradford sat motionless, lips pressed tight. The younger attorneys at his table stared at their notes, unable to meet his eye. Crockett's voice grew steadier, stronger. "The harm here is threefold. The loss of autonomy when data is taken without consent, the ongoing exposure as that data circulates beyond control, and the tangible risks created when intimate personal information is commodified." She drew another breath, her voice almost quiet now. This court stands at the boundary between old law and new reality. If the law cannot recognize this harm, then privacy, one of the foundations of American liberty, becomes a hollow promise. When she finished, the silence was absolute. For a long moment even the judge didn't speak. Then softly, "Thank you, Counselor." He turned toward Bradford. "Your reply?" Bradford rose, but the certainty was gone. His once smooth cadence faltered as he tried to salvage his argument. "Your Honor, while Congresswoman Crockett's remarks are eloquent, they don't change controlling precedent." Leon stopped him. "Address Thompson versus Datacorp, Mr. Bradford. How do you reconcile it with your position?" Bradford hesitated. Your Honor, Thompson was wrongly decided. Leon's expression hardened. So you ask this court to reject the reasoning of another circuit, while ignoring the facts presented here that directly align with it? Bradford swallowed, his answer dissolving into silence. Leon nodded slowly, a gesture that seemed both final and reflective. I've heard enough. He rose from the bench. Counsel, your preparation today has been exceptional. Congresswoman Crockett, your argument was one of the most precise and principled I have heard in this courtroom. The issues raised go to the very heart of how law must adapt to modern life. He gathered his notes. This motion is taken under advisement. Court is adjourned. The gavel struck once, sharp, resonant, final. As Leon disappeared behind the chamber doors, the tension broke like a snapped wire. The room erupted. Whispers, hurried notes, flashing cameras. Law students stared at Crockett as if they'd just witnessed a live masterclass. Bradford's team avoided eye contact, packing their papers in grim silence. At the plaintiff's table, Crockett allowed herself the smallest exhale. Her co-counsel leaned over, eyes shining. That, she whispered, was brilliant. A clerk approached and handed Crockett a folded note. Inside, written in Judge Leon's careful hand, were the words, In 2 decades on this bench, I've rarely seen constitutional principles argued with such clarity. The law needs more advocates like you. Crockett folded the note gently, slipped it into her briefcase, and smiled. The battle was far from over, but something fundamental had already shifted. For the first time in years, the law had truly listened. The courthouse emptied slowly that afternoon, but the echoes of the hearing lingered long after the marble corridors had gone silent. Outside, gray clouds hung low over Washington, the air thick with anticipation. Reporters gathered at the steps, voices overlapping, microphones thrust forward, desperate for a soundbite. Congresswoman Crockett, did you sway the judge? Do you believe this case will move forward? Are you ready to take on tech giant? Crockett didn't answer. She moved through the crowd with quiet resolve, her face calm, her posture unbroken. When a young reporter called out, Do you really think you can win? She paused for just a second and said softly, Winning isn't the goal. Truth is. Then she stepped into her waiting car, leaving the noise behind. That night, her office was quiet except for the hum of a desk lamp. Papers lay scattered across the table. Legal briefs, constitutional notes, fragments of old Supreme Court opinions. A cold cup of coffee sat forgotten beside her. The letter from Judge Leon lay open, his handwriting still visible in the warm light. The law needs more advocates like you. She read it once more, folded it carefully, and placed it beside her files. Her phone buzzed with a message from her chief of staff. Tech giant just called your hearing political theater. Should we respond? Crockett typed back, No, let the record speak. She leaned back, staring at the ceiling, the weight of the day pressed against her shoulders. This case wasn't about one courtroom anymore. It was about the line between privacy and power, and who would control that line for the next generation. A week later, at exactly 9 a.m, the court's ruling was posted online. Motion to dismiss. Denied. The word spread across the country like electricity. Within minutes, news alerts blared across every network. On the courthouse steps, the crowd erupted in applause. Judge Leon's opinion was long, detailed, and devastating. The unauthorized sale of personal data, absent consent, constitutes a concrete injury to autonomy and dignity. The right to control one's personal information is not a modern convenience. It is an extension of liberty itself. For Jasmine Crockett, it wasn't a victory. Not yet. It was an opening. A door that had been closed for decades finally cracked wide enough for light to enter. Tech giant would now face discovery. Their secrets, hidden deep within encrypted archives, would be forced into the open. Across the city, William Bradford stood in his sleek office, staring at the breaking news on the television. "We're appealing," he said sharply into the phone. On the other end, Tech Giant's general counsel agreed without hesitation. "Do it fast, quietly. She cannot win." Bradford promised to bury the case under motions and procedure. But as he hung up, Doubt crept in, a feeling he hadn't known in years. Crockett's argument still echoed in his mind, sharp and unshakable. Meanwhile, Crockett's office became a war room. Phone lines buzzed nonstop. Journalists demanded interviews. Privacy organizations sent statements of support. She ignored them all. Instead, she focused on the next step, uncovering what tech giant was hiding. Weeks later, in a sterile conference room lined with glass, she sat across from Daniel Mercer, tech giant's chief data officer. A court reporter adjusted her machine. The tension in the air was electric. "Mr. Mercer," Crockett began, "how long have you served as chief data officer?" 7 years, he replied. During that time, she asked calmly, "Did tech giant ever collect data through inactive devices, microphones, cameras, when users weren't actively using them?" He hesitated. "Not without consent." She slid a document across the table. "Exhibit 14. Read the second paragraph." Mercer looked down, his voice low. "Collected ambient audio is anonymized post-capture to enhance contextual advertising algorithms." "Ambient audio," she repeated. "That's sound recorded without user knowledge, correct?" His attorney objected weakly. "Vague." Crockett didn't flinch. "Answer the question." Mercer shifted. "Yes, technically." Her expression didn't change. "And that data was sold to third parties?" He hesitated again. "I'd have to check the—" Crockett placed another document in front of him. "Here are the records. I'll help you check." For hours, the questioning continued. Each answer another thread unraveling a web of deceit. By the time the deposition ended, Mercer had confirmed that tech giant collected hundreds of terabytes of data from inactive devices, voice recordings, location logs, even private messages. Most of it was sold, anonymized only in name. When Crockett walked out of the room, the defense team sat in stunned silence. They knew what she had just done. Exposed a truth they couldn't bury anymore. Within weeks, fragments of those truths began to leak. Emails, memos, and internal presentations appeared in the press. The headlines came one after another. Tech giant harvested audio without consent. Documents reveal sale of hidden user data. Congress demands inquiry into corporate surveillance. Public outrage erupted. Stock prices fell. Executives resigned. Crockett said nothing. Every time reporters reached out, her office replied with the same 3 words: "We'll see them in court." Months later, the trial began. Cameras crowded the courthouse steps, and the air buzzed with anticipation. The world was watching now. Inside, the courtroom was filled to capacity. Judge Leon presided once again, his demeanor grave but calm. Bradford opened with measured words, stripped of his usual bravado. "Tech giant acknowledges some oversights," he said, "but denies any intent to harm. No plaintiff has shown tangible loss." When Crockett stood, the shift was immediate. Her voice was quiet but certain. "Your Honor, intent does not erase violation. Oversight does not erase exploitation. The harm here isn't theoretical, it's structural. They built profit from intrusion." She held up a single memo, the same one Mercer had been forced to read. "They called it passive listening data. But there's nothing passive about it. It's surveillance." Over the following days, the courtroom became a battlefield of truth. Experts explained how algorithms dissected private lives for advertising profit. Ordinary citizens testified about eerie coincidences, targeted ads about things they had never typed, only spoken. Piece by piece, the illusion of anonymity collapsed. Through it all, Judge Leon listened, taking notes in silence. When the final day came, the courtroom was packed beyond capacity. Crockett rose for closing arguments, her tone measured and intimate. "Your Honor, this isn't about technology. It's about power. The power to decide who owns the truth about our own lives. The Constitution was written to protect liberty from intrusion. Today, that intrusion wears a corporate logo." She gestured to the evidence table. "These documents show deliberate deception, profits made by selling what was never theirs to sell. The question is simple. Do Americans still have the right to privacy, or is that right an illusion we click away without realizing it?" Her words hung in the air, sharp and unwavering. When she finished, she simply said, "We rest." Bradford's closing was subdued. He spoke of innovation, progress, the economic value of data, but the conviction was gone. Even he seemed to know the verdict had already begun to form in the judge's mind. Weeks later, the ruling arrived. Judge Leon's decision was clear and historic. Privacy, the control of one's personal information, is a fundamental element of liberty. No corporation, however vast, may disregard that principle. The harm here is real, the violation undeniable, the accountability overdue. The judgment reverberated through every corridor of power. Tech giants' market value plummeted overnight. Congress began drafting sweeping new privacy legislation. Across the world, governments took notice. And Jasmine Crockett, the Congresswoman who had faced a trillion-dollar empire, became a symbol of resistance and reform. Yet she refused to take a victory lap. When asked what came next, she simply said, "We keep going." That evening, when the courthouse was empty again, she returned to the courtroom alone. The wooden benches glowed faintly in the amber light of the chandeliers. She walked to the center of the room and stood still, listening to the silence. This was where it had all happened. The confrontation, the doubt, the turning point. She reached into her bag and unfolded Judge Leon's note once more. "The law needs more advocates like you." She smiled quietly to herself. Then she folded the note again and placed it back in her pocket. Outside, the night air was cool. Reporters waited at a distance, cameras off for once. The city lights shimmered across the wet pavement. Crockett took a deep breath and stepped out into the open, the faintest trace of satisfaction in her eyes. For the first time in years, justice had felt tangible, not as a promise but as something real, something earned. The rain had stopped, and in that calm, beneath the silent glow of Washington's monuments, Jasmine Crockett walked away from the courthouse knowing that the system, at least this once, had chosen the people over the powerful.